Good afternoon and welcome to the Tennessee Court of Appeals. First of all, I want to thank you for participating with us on this video live streaming oral argument. I'm sure that this is not what you thought you would be doing 6 months ago, but it has obviously become the best way for us to conduct business and to conduct oral arguments and make sure that everybody is as safe as possible. So we appreciate you and your clients agreeing to participate with us. But before we get started and before we call the case, let me introduce your panel for this afternoon. You have Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg, and we'll be your panel. Obviously, both of you have been to the Court of Appeals before, and you know how this what our procedure is, but each of you will be given 15 minutes to make your oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you introduce yourself and before you begin your argument. You may reserve up to 5 minutes of rebuttal time, and the appellee gets no rebuttal time. I think that pretty much covers everything. We do want to tell Mr. Hibner and his staff how much we appreciate them putting all this together for us, as well as the AOC technology staff who also do a wonderful job. So, Mr. Hibner, if you would call this case, please.
Heun Kim et al. Versus State of Tennessee.
All right, we will hear from the appellant. Oh, I'm sorry, Mr. Holiday. Go ahead.
Sorry, Judge. May it please the court, Chuck Holiday for the Kims. I would request 4 minutes for rebuttal, please.
All right, sir, you may proceed.
This appeal centers on the issue of proximate cause. Proximate cause has been described as a hopeless riddle, a fog, a concept that lurks deep in tort law's darkest corner. Professor Kenneth Vinson once likened it to a legal Moby Dick that surfaces at awkward moments and hypnotizes juries and judges into a shell game where ostensibly they are seeking concrete facts, but below the table they are actually engaging in political choices. Prosser and Keaton have argued that proximate cause is really a question of legal policy. The trial, this case, the legal policy question is the issue of whether a defendant that violates an industry safety standard should be held responsible for a foreseeable harm. The trial court said no in this case, but because this was a bench trial, this court will have to come to its own conclusion using considerations of public policy, precedent, and common sense.
Mr. Holiday, before you get started too deep, I realize that you're appealing, but the trial court made several findings of fact that perhaps could impact this. Do you dispute any of the findings of the fact the trial court made as it affects the proximate cause argument?
Judge, I'm not sure which findings of fact you would be referring to. I think generally the findings of fact, as this court noted in the first opinion, were generally undisputed, and that the findings of facts, I can't think of any at this moment that we are disputing.
I know the trial court has a chronology of what transpired here. The door was unlocked. The minor child goes in the room, and obviously what occurs. But I just wanted to make sure that there was not a dispute about any findings made by the trial court other than the legal analysis it utilized in finding that there was no proximate cause here.
I don't recall any at this point, Your Honor.
Okay.
I think that each of the prongs of the McClanahan test, when we get to the legal aspect of proximate cause, support finding it. Under the first prong, the failure to follow an industry standard was a substantial factor in Daniel's injuries. This is not a case in which someone was injured and the defendant's conduct made the condition worse. The state's negligence literally unlocked the danger here. The second factor, the applicable policies and standards, those actually favor liability in this case. And third, the only real factor at issue in this case is whether the harm was a reasonably foreseeable probability. The state argues that it's not foreseeable because, as the commissioner found, no one had ever fallen off of the inn's balconies before. Imagine if a cruise ship argued that it didn't have life jackets because it had never sank. Imagine if a bar argued that it wasn't foreseeable that an overserved patron would drive drunk and cause a wreck because it had never happened at that bar before. Tennessee Pattern Jury Instruction 3.22 defines proximate cause, although it's been relabeled legal cause. And it says that liability may be imposed where the defendant should have foreseen the general manner in which the injury occurred. It's an objective standard that does not depend on the defendant's actual knowledge, but society's collective knowledge of the risks inherent in certain activities. That's why a cruise ship would be absolutely liable if it sank and failed to have life jackets. And that's why a bar can be liable for overserving a customer who later causes a wreck, even though it's never happened at that bar. And that's why in this case, the state should be liable for Daniel's injuries, even though no one had ever fallen at the inn before. We know as a society that unsupervised children with access to windows and balconies present a foreseeable probability of harm. We've known that since we moved out of log cabins and into multi-story buildings. Looking at legal cause foreseeability under McClenahan, it is certainly the type of injury then that the defendant generally should have foreseen. And this is true whether or not Daniel engaged in misconduct. While everything in this case points to the conclusion that Daniel's fall was accidental, the law has long recognized that children often act childishly. Both the attractive nuisance doctrine and the playground doctrine are premised on unsupervised children acting childishly. The law deals with this with two realities. First, we have a premise that children are incapable of negligence. And second, we impose a higher duty on those who come in contact with children. Take, for example, the case of Bloodworth versus Stewart, the 1968 Tennessee Supreme Court case. I didn't come across it until after briefing. The site is 428 Southwest 2D 786. This case is premised on children who are unsupervised acting childishly. In that case, the defendant contractor was aware that in the evenings, children from a nearby playground would go to a construction site and play on it. Although aware of that, the defendant did not hire a watchman or put up a fence. The court noted that the proof at trial showed that it was an industry standard to put a fence around a commercial construction site when it was near a playground. A young boy went onto the construction site, was injured when his foot hit a piece of scaffolding and a large piece of concrete fell on his leg. The jury found for the plaintiff and the Supreme Court affirmed. Now, it's unlikely in that case the defendant saw the exact manner in which the injury occurred, but it's one they generally should have foreseen. And contrary to the commissioner's finding in this case, it was unforeseeable that Daniel would climb on the balcony railing. It's exactly the type of childish behavior we expect. It's reasonably foreseeable that an unsupervised child with access to a high window or balcony may fall for various reasons, and climbing on something without regard for the danger involved is a fundamentally childish behavior. Because it's a childish behavior for someone as Daniel's young age to do that, the motivation for their action is irrelevant. As this court held in the first appeal, it's sufficient that harm in the abstract could reasonably be foreseen. And just as the proof in Bloodworth showed that fences were customary, the proof in this case showed it was customary to lock the doors to clean in vacant rooms. It's these custom and policies that establish foreseeability in this case and set it apart from the Landry case, the state cited as supplemental authority. In the Landry case, the plaintiffs could not point to any policy against stacking chairs upside down on tables. A policy is really nothing more than a plan to prevent harm. It's the embodiment of foreseeability. Without that proof, or without proof of prior injuries, the Landry plaintiffs were unable to prove a remote possibility as opposed to a reasonable probability. The safety policy in this case established a reasonable probability of harm in the abstract, and the harm that occurred is within the constellation of harms that generally should have been foreseen. Your Honors, the other issue in this case with regard to the notice of appeal issue, I would say this.
Is that even an issue?
I believe it is, Your Honor, because there's a question as to which notice of appeal is operative. There's a Court of Appeals opinion that says that filing a notice of appeal from a claims commission with the Court of Appeals is inoperative. And so there's a question in this case as to which one controls and which one is actually applicable. And I would say this, I shouldn't have to show up at the dance with belts and suspenders just because the dress code is unclear as to which is required. A claimant has a right to know the proper manner to perfect an appeal and should not be left to guess. And so
I assume though, and we'll hear from the appellee. I thought the appellee had conceded that issue, but go ahead and make your argument. We'll find out.
Judge, I believe their position, according to their brief, was simply that they were not taking a position on it because they didn't feel it was an issue in the case. I didn't see that they had conceded that one way or the other was correct.
Well, I conceded that you had properly appealed the case. Let me say it like that.
I think they had, because I filed it both ways, but we don't know which way they conceded was correct. For these reasons, Judge, the decision should be reversed and remanded. Thank you.
All right. Thank you. We will hear from the appellee.
Good afternoon, Your Honors. Laura Miller here on behalf of the state of Tennessee. To address your last question first, Judge Stafford, you are correct. The state is not taking issue with the appropriateness or correctness of the plaintiff's appeal here. So we have not viewed the proper mode of appeal as an issue in the case.
Thank you.
But turning to the proximate cause issue, the state would ask that this court uphold the Claims Commission judgment in favor of the state in this case, based on the claimant's failure to prove that the unsecured door to the guest room was a proximate cause of the injury. The commissioner's ruling on lack of proximate cause and lack of foreseeability, more specifically, were findings of fact that are entitled to a presumption of correctness on appeal, unless the preponderance of the evidence is otherwise. And the state respectfully submits that the commissioner's ruling on lack of foreseeability is supported by the preponderance of the evidence here.
Ms. Miller, let me ask you a question. Does it make any difference that it was a child versus if it had been an adult that had gone into the room?
No, Your Honor, it's the state's position that it does not. And I think what it really boils down to is the fact that there was an intentional act of putting oneself in harm's way that is not foreseeable, regardless if it's a child or an adult who's doing it. And the other fact that—
What standard is the child held to?
So while there is sort of this under the comparative fault principles, you know, there's a rebuttable presumption that a child cannot be negligent, but when you're talking about the intervening cause or sort of foreseeability context for the liability of the defendant and trying to determine whether the child's action was foreseeable, I don't think that comparative fault rebuttable presumption necessarily applies. The focus is more, was this intervening in intentional conduct, whether it was a child or adult, putting themselves in harm's way, was that event foreseeable? So I think there's a distinction between applying that special rule for comparative fault of children versus applying it to foreseeability in the instance of proximate cause, if that makes sense.
Well, would the comparative fault apply to the child, or might it apply to the parents for allowing the child to be unsupervised? But I'm having a hard time understanding, since the child can't be negligent, how you can have the same standard for the child under those circumstances as you can have for an adult.
And the Leach case actually does address that. We cited the Leach case in our brief. And the observation made there, and I'll quote it, was that the intervening act of a child may be the responsible cause of his injury, although he himself cannot be held guilty of negligence. So I think the Court of Appeals has previously made a distinction when you're dealing with the two contexts. And you also made a good point, Your Honor, that in this case, the child was unsupervised, but importantly, the hotel did not know that fact. So, plaintiff makes a lot of arguments about a heightened duty of care to take into account childish instincts. And while we're not talking about duty of care here, we're talking about proximate cause. That whole argument that you have to take into account childish instincts is based on the assumption that the defendant knows the child is unsupervised. In this case, there was no evidence to establish that the hotel had any reason to believe that Daniel was not with his parents and under supervision at all times.
I'm not sure what, maybe I'm missing, I'm not sure what that has to do with it. The idea here is that the Claims Commission found that the state was negligent in allowing the hotel room to be open. So is it not foreseeable? Are you saying it's not foreseeable that an unsupervised child would enter the room? Is that the idea?
Correct.
I guess my thought is that that would seem to me to be potentially foreseeable, at least. And then if it occurred, that something might occur that might not occur if it was an adult that happened to be entering the room. I guess I know that may be confusing, but that's my thought on it. And I was wondering if you can respond to that.
And I'm hoping I'm understanding you correctly. And I think what the commission was getting at in making the finding that, this was an unforeseeable intentional act, even though it was a child. I think the point is that it's not foreseeable that a child would be unsupervised at any point, any place in the hotel, and therefore it was unforeseeable that he would even be going into this room without a parent watching. And therefore, to find that the hotel had some reasonable grounds to foresee, any kind of childish act that would occur in the room, including climbing onto the balcony, would require essentially that the hotel childproof the entire place.
Well, the hotel was aware that there was as I understand it, there were two conference rooms, one of which the parents were in attendance, and one of which there were a bunch of children in attendance. And I understand there must have been some supervision in that room, but the hotel was aware that there were a bunch of kids in a room without their parents. Let's put it that. I think we know at least that much as I read the briefs.
Well, I would dispute that they knew that there were a bunch of kids not under adult supervision. I think the testimony and the commissioner's finding was that the church group that the claimants were with they had checked out of all their rooms that morning and had reserved two conference rooms in the ground floor of the hotel, one for housing the activities of the children who were supposed to be under supervision. So the hotel reasonably believed that these children were under supervision in that location. They had no reason to believe that any children would be unsupervised in a vacant guest wing of the house, much less any one period, because as I said, the group had already checked out that morning. And indeed, it was the end of Labor Day weekend. Pretty much everyone had checked out by the time this accident occurred. The checkout time had passed. So no, they did not expect anyone to be in that wing of the hotel. So this isn't like it was, a playground or a pool where you might expect to find children. This was a vacant wing of the hotel. So getting back to sort of the substance of my argument, that before getting into the evidence presented, I did want to speak a little bit about the actual standard that's required for establishing foreseeability in the context of proximate cause. The claimants argue that proximate cause is established if the state could foresee harm in the abstract of a child gaining access to a vacant guest room. But recent Court of Appeals opinions have also recognized that the injury must be probable and foreseeable from the vantage point of the defendant at the time of the injury. So although foreseeing the exact manner of the injury is not required, the injury must still be a reasonably foreseeable probability, not just a remote possibility. In other words, the same harm can be expected to recur if the same act is repeated in a similar context. And this is important when considering the purpose that the foreseeability analysis serves in the context of proximate cause. Plaintiffs argue in their brief that foreseeability analysis is essentially the same between duty of care and proximate cause, and they cite a lot of cases that deal with duty of care rather than proximate cause. But the proximate cause analysis is different than duty of care, and the question, unlike in duty of care, where the question is, was the conduct by the defendant reasonable? In proximate cause, the conceptual question is whether the harm that resulted from the defendant's conduct reasonably flowed from the defendant's breach of duty. Or in other words, was the harm so tenuous and far removed from the defendant's conduct that it precludes a finding of foreseeability? So to answer that question, the plaintiff cannot just broadly rely on the assertion that some type of abstract harm could occur, and instead, you have to look at the probability of the injury that did in fact occur. And that's exactly what this court did in its recent decision in the Landry case, which the state cited in its notice of supplemental authority. In that case, the alleged dangerous condition was chairs that had been placed upside down on top of a cafeteria table in the school. And the plaintiff argued there that the injury was foreseeable in the abstract because the chairs could fall off the table if they were bumped, and testimony established that students did sometimes bump into the chairs and knock them off. And there would have been no risk of the chairs falling if the custodial staff had simply taken the two chairs down after they cleaned the cafeteria. Those arguments are really similar to the arguments the plaintiff proposes here, in which they argue that it was foreseeable in the abstract that a child could be. I'm sorry.
Not sure what that is.
Yeah, I'm getting some feedback, but it stopped now. Are you all hearing me clearly again?
Yes, go ahead.
Okay. The perils of technology.
Oh, yeah.
The arguments asserted by the plaintiff in the Landry case are a lot similar to what's being asserted here by the plaintiff. For example, the plaintiff is arguing that it was foreseeable that a child could be injured in some way if he or she gained access to a vacant guest room, and that children have been known to fall from heights. And the risk of injury here would have been stopped if the guest room door had simply been locked. But in Landry, the court upheld summary judgment on proximate cause, holding that the plaintiffs could not establish a reasonably foreseeable probability of injury from the chairs on the basis of those type of arguments. And the factors the court noted in support of its decision on summary judgment were that there had been no prior injuries from chairs falling and injuring anyone, no prior concerns voiced to the school about upside down chairs injuring anyone. And then the court actually examined the manner of the injury itself, and it noted that this injury did not occur because of the chairs being placed upside down per se, but instead because the plaintiff tripped on the strap of his backpack, and as he was falling, pushed the chair he was in away from him, which knocked into one of the chairs that was upside down on the table, and that caused the chair to fall off. So based on the improbable manner of the injury that occurred and the fact that there had been no prior accidents like this involving chairs, the Landry Court upheld summary judgment on foreseeability grounds. Here, just as in the Landry case, the plaintiff can't just rest on the assertion that some type of harm in the abstract could occur from a guest room door being left unlocked. Instead, the plaintiff must establish that there was a reasonably foreseeable probability of the injury that actually occurred. And turning to this case, the manner of the injury here that occurred was that an unsupervised child fell off a guest room balcony after intentionally climbing onto it. The preponderance of the evidence at trial establishes that such an occurrence was not a reasonably foreseeable probability. The undisputed testimony was that there were, just as in Landry, there were no prior incidents of anyone falling off a balcony, adult or child. No prior incidents of guests injuring themselves in a vacant room, period. And there was no proof that the guest room nor the balcony were dangerous in and of themselves. The parties stipulated that Daniel was too short to have fallen over the balcony railing accidentally because his center of gravity was too short relative to the height of the balcony. And the testimony of Daniel's mother was that she and Daniel had been out on the balcony earlier and that she did not feel that the balcony or the guest room itself were unsafe. So the hotel had no reason to believe that the guest room presented a danger or that a guest would be injured in a vacant room. And as the commission noted, Daniel was not injured here due to a dangerous condition or defect in the guest room. He fell because he undertook an affirmative act by climbing onto the railing. And the hotel could not have reasonably foreseen that a guest would intentionally put themselves in danger by climbing onto the top of the guardrail. The claimants put a lot of emphasis on the hotel secured door policy and the industry standard for securing doors, but that policy does not establish foreseeability. The undisputed testimony at trial was the purpose of that policy was to prevent unauthorized people from getting into rooms and harming guests or harming property. It was not to prevent a guest from getting into the room and harming themselves. So the existence of that policy was not to prevent this type of harm, and it does not establish foreseeability in this case. Therefore, it's the state's position that the preponderance of the evidence supports the commissioner's ruling in this case. Thank you.
Thank you. Mr. Holliday, you have your rebuttal time.
Thank you, Your Honor. Your Honor, I'd point this court to its previous decision in this case in which it quoted from the Barra case and talking about proximate cause said, it is sufficient that harm in the abstract could reasonably be foreseen. The state doesn't like that law, but that's what this court held the law was in the first trial or the first appeal of this case. The other thing I would note from this case, the first appeal was the court said, we ask regarding proximate cause, we ask whether the law should extend responsibility for negligent conduct to consequences that have occurred. And that's the question here. And when you have that type of a standard, you have a much different case than the Landry case. Suppose that in Landry, the plaintiffs had put forward that there was an industry safety standard, that chairs are to be taken off of tables afterward because the chairs can fall and damage the floor and they may hit a child. I would submit to the court that that decision would have been a much different case if that standard existed, because that's the type of standard we had in this case. We had an industry safety standard. And go back to Judge Stafford's first question about disputed fact issues. We do dispute with the state that it was undisputed that the reason we cite in our brief where the testimony was that several of the state's employees admitted that one reason for that standard was safety. So I think if you look at that, you would see that's completely different from Landry. The Leach case, again, is a much different case. If the court looks, we cite in our brief, there are several reported cases after Leach, the Potter case, and I think the Edens case. And both of those cases indicate that if we're going to get into the issue of an intervening superseding cause, it's normally when somebody intentionally commits suicide, and that Potter did not change that. And so to the extent Leach would support the state's argument, I think the reported cases would control over the unreported case. Finally, with regard to Judge Golden's point about a child versus an adult and foreseeability, that raises an interesting question that I'm not sure the case law is very clear about. We argued in our brief that, as this court and other courts have recognized, foreseeability and duty and foreseeability and proximate cause are often indistinct in their discussions. But one area we suggested that we should look at is that in duty, we clearly, under the state's law, look at the gravity of the harm, and the greater the gravity for harm, the less the burden has to be on the defendant. So if there's a great chance of harm, then the defendant, the likelihood of harm has to be less or minimal for the defendant to comply with that. And whether that applies in proximate cause analysis, I don't think I've not found a clear answer in the case law, but we've argued that it should be, and that should be applicable to this case. The end result in this case is that the policy the inn violated was an industry safety standard. Inn employees were trained on it to follow it, and their failure to follow it was a legal cause of Daniel's fall. If the court finds otherwise, the message to innkeepers across this state will be clear. The safety of child guests rests solely with their parents. Thank you.
Thank you. Thank you both, counsel. We appreciate your arguments. We'll endeavor to get you an opinion as soon as we can. Again, we appreciate your participation in this process. We appreciate Mr. Hibner and his staff and what they do to make it happen, as well as the technology staff of the AOC. Mr. Hibner, if you will recess us to the call to the next docket, please.